You said June 10th?
June 5th at
June.
1:30. That's what I said. Now, what Jennifer said, that may be different. Let's see let's have her confirm the date for us, please, Jennifer.
A simple speeding ticket expungement should be routine, right? Not today. Cody Bacon wants a 2017 violation removed, but prosecutors are bringing up far newer legal troubles that could change everything. What starts as a minor record cleanup request quickly becomes a debate about public safety and accountability. Subscribe for more dramatic courtroom breakdowns.
Judicial District, the District Court of Butler County, Kansas. First up, I see Cody Bacon will be on the record now in 2017, TR 3796, State of Kansas versus Cody Wade Bacon. Please announce appearances.
Jared Regier on behalf of the state.
Please, the court. Mr. Bacon appears via Zoom with counsel Kevin Zolator.
And I understand this matter comes on for a motion for expungement. Is that right, Mr. Zolator?
Yes, Your Honor.
And does the state object to that motion, Mr. Regier?
Yes, Your Honor, for reasons that the state will address on the record today.
All right, Mr. O'Hare, if you want to make just a brief foundational statement of why you believe your client is entitled to this expungement at this time.
Your Honor, I don't know why the state is objecting. This is a speeding ticket,
right,
from 2017 that has been paid, has been closed. The statutory requirements have been met. I mean, if court needs the laws, KSA 216614, Section A.
No, I don't need a lot. As I read through this, I was, as you said, wondering why there was an objection. So, Mr. Aguirre, do you want to state the grounds for your objection at this time? It appeared on its face that it was appropriate for expungement, but please go ahead.
Yes, Your Honor. The state does acknowledge that the defendant might be entitled to expunge it in this case at this time, since the more than 3 years lapse have passed under subsection A1 of the KSA 216614. However, the state does have concerns under subsections H2 and H3 of the same, which provides, quote, at the hearing on the petition, the court shall order the petitioner's arrest, report, conviction, or diversion expunged if the court finds that the circumstances and behavior of the petitioner warrant the expungement and the expungement is consistent with the public welfare. State's information is that the defendant was on diversion for DUI from 2023 to 2024, as well as convicted of disorderly conduct in another jurisdiction on 2025. So therefore, in light of the defendant's continuing course of conduct, the state's position is that the circumstances and the behavior of the petitioner do not warrant the expungement, and the expungement is not consistent with the public welfare.
With that additional information, what would your response be, Mr. Zolator?
Your Honor, this is a speeding ticket. It's not even related to a disorderly conduct or a DUI. And I've talked to Mr. Bacon about this. I don't know that this has any effect on his record whatsoever. I don't think any employer looks at this and goes, "Oh my gosh, you had a speeding ticket in 2017." He just wants it off his record to try and just clear his record, or for whatever reason. But because someone had a DUI and got a diversion for that, but 2 years ago, or 2024, and a disorderly conduct over a year ago, I don't think that warrants not allowing someone to have a speeding ticket expunged. Again, it's almost 10 years old. What the state thinks they get out of having this on the record is some sort of punishment to hold over his head because he's got a disorderly conduct. I don't understand that. I don't see the logic in it at all. I've told Mr. Bacon, I don't, why, getting this expunged does nothing for him as far as insurance purposes or whatever. It's off his record for those kinds of purposes. It just cleans it up a little bit for him. He still has the DUI on his diversion on his record. He still has the disorderly conduct. I can't fathom the logic here that the state is objecting because of those reasons. So I would ask the court grant the expungement.
All right. Anything further? I'll give you the last word, Mr. Regier.
There's nothing further to add beyond what the state has already stated on the record, Your Honor.
All right. Thank you. Well, with the defendant getting the speeding conviction, and had he not gone out and gotten a DUI or disorderly conduct, I think it would be kind of what they call the slam dunk, that there's no reason to keep it on his record if he's asking for expungement. However, I am very troubled as a court about someone with a speeding ticket going out and getting a DUI. He's gotten a more serious violation than the disorderly conduct. I don't find that the expungement is consistent with the public welfare. He does continue to get violations of the law, and they're continuing to get more serious over time. So I think it is consistent with public welfare to keep this on his record, not to hide it from it or remove it from his public record. It's just one more piece that needs to be kept in order as he goes through getting into trouble with the law and perhaps exposing the public to more danger. Speeding could be a dangerous situation, but DUI is more dangerous, and each time disorderly conduct is dangerous, he just keeps adding to it. So at this time, the motion for expungement is denied in that the defendant has not shown that expungement is consistent with the public welfare. Motion denied at this time. And if there's nothing further, of course, that can always be appealed, but that's this court's finding at this time. And we'll be in recess on Cody Bacon. Is Cody Bacon here present or just through counsel?
He's on.
Where are you, Mr. Bacon? Cody Bacon? I don't see him. Maybe he's already gone. All right. Thank you, Mr. Zolotor. Have you anyone else on this docket that we should take up?
Your Honor, I have Alexander Moreno, 25 CR 392. This is
Thank
for
you.
case.
And Your Honor, insofar as that matter is concerned, I will defer to my colleague, Mr. Baca.
Very well. We will now be on the record in BU 2025 CR 392, State of Kansas versus Alexander Krishan Moreno Allen. Please announce appearances.
Thank you, Your Honor. Joseph Baca appearing for the state of Kansas.
Your Honor, Mr. Moreno appears via Zoom with counsel Kevin Zolotor.
Any announcements, Mr. Zolotor?
Your Honor, this is Mr. Reynolds' case. He is requesting a continuance of 4 weeks.
Any objection from the state?
Brief moment, Your Honor. Just making sure. Your Honor, I would have no objection. I do see this was in August of 25 as kind of a start date. I do have notes from Ms. Norris. If the defendant needs an offer, maybe he's already received that from her, but no objection for today. State might be objecting to any further continuances since this has been going since August of 25.
Is there any alleged victim here today that wishes to be heard on the matter of continuance? Or any other matter? Is there a Lakin Kafka David present?
Your Honor,
Yes.
I do have 3 people in the waiting room. One is just a number and will not answer me.
Well, we can't help them if they're just a number. You might just disconnect them. Maybe they'll call back and provide the requested information. But if it's not Lakin Kafka David, then all right. And then I probably have the clerk tied up so that she can't give us another date. I will grant the continuance in an effort to try to resolve this in a appropriate order to the benefit of the defendant and the alleged victim.
Your Honor, the next date would be July 6th.
July 6th?
Mm-hmm.
Does that work, Mr. Zolotor?
After the heated expungement dispute, the courtroom shifts gears to Alexander Moreno Allen's case. This hearing isn't about guilt or innocence today, it's about timing. The judge grants another continuance while balancing the interests of both the defendant and any potential victim. Delays can be strategic, but they also keep everyone waiting.
Give me, let me check, Your Honor. I was not looking that, looking that far out.
Now, I wish we didn't have to.
Yes, July 6th works with Mr. Reynolds' calendar.
Mr. Reynolds, okay. All right, this is continued at the defendant's request to July 6th at 9 a.m. Defendant will be continued on his bond with all existing conditions, including any no contacts, Mr. Marino Allen, and that is the $1,500 surety bond you posted back there on August 30th. The added condition.
I don't think anyone in
Court security, I'm hearing you. Are you intending to be part of this hearing? Apparently not. You just muted. Okay.
Judge, that was
So,
walk-in that had her camera going.
oh, okay. All right. Well, that looks like that's Trudy Haynes. She's
Yes,
not
ma'am.
up yet. Okay. All right. So this is continued at the defendant's request, July 6th at 9 a.m. All existing bond conditions and the new condition added that the defendant reappear by Zoom with counsel no later than July 6th, 9 a.m. Anything further from either party?
No, Your Honor.
Nothing from the state, Your Honor.
All right, we'll be in recess. Mr. Marino Allen is excused. Mr. Zolator, anyone else you want to take up?
No, Your Honor.
All right, thank you.
Thank you.
You're welcome. You may go. Mr. Weissman, who do you want to take up?
Judge, I have Austin Schwartz, and I also have Braylon Daniels. I'd like
All
to
right,
take
let's-
up Austin Schwartz first.
Yes, we will do that. On the record in BU 2025 TR 129, State of Kansas versus Austin M. Schwartz. Please announce appearances.
Your Honor, Joseph Baca appearing for the state of Kansas.
Good morning, Your Honor. Rocky Weichman on behalf of Austin Schwartz, who appears behind me.
All right, and what announcements, if any, on his case, sir?
This is a driving on suspended case. I'm actually working to trying to get him reinstated. I've got some jury trials coming up in May, and I've got a vacation planned. If I could have June 8th for another appearance on him, that would be awesome.
I'm showing speeding and driving with expired tag. Is that what you're showing, Mr. Weissman, Mr. Baca?
Those are the charges that I have as well, Your Honor.
You may have some other matters in another case, but the case we're on today, that's what I'm looking
Oh,
at.
I'm sorry. I'm sorry.
No problem.
Yeah. What if you could set this over to June 8th for me? I'll send an email. Is it Joe or is it Jared that I need to send that to?
It would be Jared.
Okay. I do have his registration receipt where he did get that. Would you be willing to dismiss that and he'll plead to the speeding right now?
Well, certainly, that'd be something we'd have to review. Judge, I can inform the court. I don't mind setting it over to review that. This has been ongoing, I think, since about April. I know Mr. Weichman hasn't been on since then, though, so I wouldn't object to a continuance today to give us a chance to review and resolve.
Judge, I don't need till June 8th on that. If you could give me May 4th on that one, I'll send the email out.
Well, let me check with my clerk here and see if we can possibly squeeze that in May 4th for possible plea.
Correct.
Okay, what do you have on there? Jen, is that which, Jennifer?
I am looking. We do not have May 4th or June 8th. The soonest
Well,
we'll
what-
have is July 6th.
Can you fit him in there somewhere in May? So maybe even put him on a Wednesday afternoon plea docket. Are you available on Wednesday afternoons, Mr. Weissman?
Yes, ma'am.
Okay, we can even put him in on a Wednesday afternoon for plea. Assuming it goes as you hope it will or think it might.
I am looking, Your Honor. As you know, your court is very full.
Yes, unfortunately.
I don't really have any. I got a bunch of stuff going on Wednesday afternoons. What about June 15th in the morning? Would that work?
All
Is that
right. Yeah, Jennifer's the gatekeeper there.
Actually, stick me on the earliest one you can, and I'll I'll find a way to get it done.
Let's stick with June 8th.
June 8th, that was one of the dates you were wanting, wasn't it?
It was, but it's going to be a
Further
crowded
away.
one.
Okay, it's gonna be a crowded morning, so if you want to get at the top of the docket, you might let her know if it's gonna be short and sweet to the point.
What
Maybe
day
she
was that, Your Honor?
June 8th, maybe she can get you put at the top of the docket, no guarantees, but maybe.
Okay, June 8th.
June 8th, 9 a.m. If you guys can
Thank
get that worked out by then.
Thank you.
All right, thank you. And it's had a few continuances, so hopefully this will be the last one.
It will be.
Okay, thank you. Mr. Schwartz, you are ordered to reappear at that date and time. This continuance is at your request. And you have not posted a bond, or you have posted? I have a 500 cash or surety, but I can't tell that it's actually been posted. If it has, there's a bond.
He did post a bond, Your Honor.
Yeah, okay, all right. That's an added condition to your bond, Mr. Schwartz. Be back here at that date and time by Zoom. All right, you may go. Mr. Weissman, anyone else on the docket?
Yes, Braylon Daniels, case number 26 TR 14.
I find that we are on.
Now the focus turns to Braylon Daniels and a planned motion to suppress. That's a major legal move because if evidence is ruled inadmissible, it can dramatically affect DUI prosecution. Notice how the judge immediately starts discussing scheduling and witness preparation. This hearing may seem procedural, but the stakes are significant.
We are on the record in BU 26 TR 14, State of Kansas versus Braylon Sky Daniels. Please announce appearances.
Here we go on behalf of the state.
Good morning, Your Honor. Rocky Weichman on behalf of Braylon Daniels, who appears behind me.
And how does Mr. Daniels wish to proceed today?
Your Honor, this is, I anticipate filing a motion to suppress on this case. If I could have the June 8th date, and I'll have it filed by then.
Well, if we're going to do a motion to suppress, I don't know that that's a good docket to do it on. I think one of those Wednesday afternoons would be better. What did you tell me about Wednesday afternoons for you, Mr. Weissman? You're not available?
In June, I'm okay.
Okay. All right,
June 10th, I'm wide open.
Mr. Regier, would that give you time for June 5th to get your witnesses and so forth?
No objection, Your Honor. Assuming that indeed a prospective motion to suppress is filed with the court in this matter.
Yes, we do need that filed in a timely fashion so counsel can be prepared, but I've never had a problem with Mr. Weissman on those kind of issues before. So you'll get that on file, Mr. Weissman, timely?
Next week.
Sounds good. All right, Jennifer, does that work? Setting this for motion to suppress June 5th at 1:30 on the traffic trial docket?
You said June 10th?
June 5th at 1:30? That's what I said. Now, what Jennifer said, that may be different. Let's see let's have her confirm the date for us, please, Jennifer.
June 10th would work.
It is June 10th. Does that work for you, Mr. Weissman?
Yes, ma'am.
Okay. Mr. Regier, does June 10th work for you?
No objection from the state as to that date, Your Honor. I would note that the information that this is a case that appears to involve one count of DUI. So,
all right. So, Miss Daniels, this is continued. Is it Miss or Mr.? Can't tell with that long blonde hair back there. Braylon is Mr. or Miss?
Miss.
Miss, okay. Well, you certainly look more like a miss from where I am, but you're far enough back I couldn't swear. All right,
I've had
Miss
that
Braylon.
conversation with her already about her name.
Okay. All right, Miss Braylon, you must be back here with your counsel by Zoom, ready to go for motion to suppress June 10th at 1:30. Any prior conditions of your bond will remain in addition to this. So you may go at this time. And we'll see you back here then.
Thank you, Judge.
You're welcome. Anyone else, Mr. Weissman?
No, ma'am.
All right, thank you, sir. You're excused, as is your client. Well, let's see. Other defense attorneys?
I have a couple quick ones, Judge.
Okay, who was that? Was that Mr.
That was
Hanson?
me, Your Honor.
Oh, well,
William
hello,
McClendon.
Mr. McClendon. All right, who do you have, Mr. McClendon?
I have Michelle Miller, which will be for plea, and then Mr. Satter, which is just the continuance, Your Honor.
Okay, we'll take up Satter first. Is it Satter or Sater, Mr. Where is he? Anybody know where is he in custody?
Judge, I'm also appearing for Mr. Patterson on Mr. Satter's other case. So I think Mr. McClendon has 26 CR 81, if I'm correct, and I have 26 CR 87, which is also for a continuance for his case.
And is he by chance in custody? Mr. Satter, if you're here, you better look.
I think that's him. I think that's him at the detention center, Your Honor.
Okay, Butler County Detention, is that Mr. Satter?
Yes, ma'am.
And sir, do you pronounce it Satter or Sater?
Sater.
All right, we are on the record in two cases, 2026 CR 81 and 2026 CR 87, each captioned State of Kansas versus Dakota James Sater. Will counsel please identify?
Thank you, Your Honor. Joseph Bach appearing for the state of Kansas.
William McClendon for the defendant and 26 CR 81.
Joseph Favre for Darren Patterson for this hearing only for 26 CR 87.
And do we have any announcements from anyone?
Judge, I'd be requesting a continuance, and I think Mr. Favre would be doing the same.
That's correct.
I've had no contact. I did not know Mr. Sater was in custody. So just need to, we can go however far the court deems necessary to go out with this. I mean, 45 to 60, but also understand the court's schedule.
Dakota Sauter's situation is becoming increasingly complicated. The court reviews multiple pending cases involving different allegations, multiple attorneys, and requests for continuances. When several cases begin stacking up at once, judges often look beyond a single charge and consider the broader picture before making important decisions.
And I'd also like to be heard on bond, Your Honor.
All right. And who said they're here for Patterson? Was that you, Mr. Favre?
That's me, Judge, yes.
And he's asking for continuance as well?
Yeah, Mr. Patterson's notes say that we need to continue the case and he needs a copy from the first appearance in his other case. But for this case, we're asking for a continuance.
All right. The 81 case that has Mr. McClendon is theft of property or services dating back to September 24th of 2025. And then the 26 CR 87, Mr. Patterson by Mr. Favre, is violation of a protection order dating back to March 4th of 26. So these are not very connected unless the violation of the protection order has to do with, well, it says April Dawn Brooks apparently is alleged to be a victim in that says 26 CR 71. So maybe he has three cases. Does anyone know?
So, Judge, he does have 26 CR 71, which I think is a felony case.
Oh,
and I'm not on that. I mean, Mr. Patterson's not on that. So I think, yeah, that's my understanding.
And what is the state's reaction to the request for continuances?
Judge, in regards to the request for continuances, I would have no objection. It does appear that first appearance on both of these cases happened just back in March. Understand that he certainly needs to meet with his attorneys, and so state would have no objection to a continuance request today.
All right. Jennifer, what's your earliest available on my docket for these misdemeanors?
July 6th, Your Honor.
Counsel both available July 6th at 9 a.m.?
Yes, Judge.
Yes, Your Honor.
All right. These cases are both continued at the defendant's request to July 6th at 9 a.m. Defendant must be back here with counsel for those hearings at that time. Now then, what is the issue on bonds? Someone said you had an issue there or a motion?
Yes, Judge. Obviously, Mr. Satter is currently unable to make his bond. I'd ask that he bond be lowered to an amount appropriate so he can be released and be able to work with me and Mr. Patterson.
Well, obviously, the court thought the previous bond was appropriate. Mr. Favre, are you asking for bond modification as well?
Judge, Mr. Patterson left no notes to that effect, and I'm not sure what his bond is in 26 CR 87.
Okay.
Certainly, if he's being held on this case, I guess I would ask for that bond to be modified. But because he has two other cases, I'm not sure if he's even being held on this case.
Let's see. He had bond. Bond was set March 13th to 26 on the 87, the 26 CR 87. Bond was set for $5,000 cash or surety with no contact with April Dawn Brooks. That was in March for $5,000. And then on the other case, the 81, the case ending in 81, the 26 CR 81, bond was set at $1,500 cash or surety with a notation that he still had a warrant outstanding, and I'm not sure if that meant on this case. Take a look and see what kind of history he has according to Odyssey. When the 26 CR 81 was filed, it didn't look like he had anything but the theft of property with the offense date of 9/24/25. Then in the 87 case, he had, well, now that one pops up, a 2007 disposed case for criminal damage, a 2011 disposed of, I know not what for. 2018, he had two thefts, one dismissed for guilty plea to the other, offense date being 9/17 of 2018. Then he had a 2018 VA 65. I don't know what county that would be. That was a theft. Looks like not sure. It looks like maybe he was found guilty. I don't know if that was trial or plea, but he was found guilty. And then he had a 26 for ag indecent liberties. It looks like that was and may still be pending from Butler County. That may be the felony you folks mentioned. It's alleged ag indecent liberties, rape, ag crim sodomy, attempted ag indecent liberties with a child, attempted ag indecent liberties with a child again, another one, a third charge of that, and then another rape charge. So that may be pending. That's out of Butler County. Offense dates dating back to 2018 and 2020, as well as 2021, and again in 25. So he has a number of things going. He's probably not just being held on these. Is the jailer there?
Yes, ma'am.
Is he being held on that felony case as well as these misdemeanors?
I believe so.
Okay. Well, does the state want to be heard on these motions, or did we get a conclusion? Did the defendant get to conclude his motions? Mr. McClendon, did you have anything else you wanted to say?
I have nothing further to add, Your Honor.
And Mr. Favre, anything further to say?
No, Judge.
All right. Prosecutor, your response?
Well, Judge, in looking at these cases, at least in the 81 case, which I believe has been the primary request, that bond's $1,500. I think that's a reasonable amount for the charges set. While it is a non-person charged crime, there still is a potential victim. Given he also has what appears to be at least 3 pending cases, I think that bond's appropriate and ask the court to keep the bond as it is for today.
Well, I think that even if he made these bonds, he might still have bigger bonds to make. And I do feel that 1,500 cash or surety is appropriate on the 26 CR 81, 5,000 appropriate on the 26 CR 87. So motions to modify bond at this time are denied. So the bonds stand and the defendant is remanded to the custody of the sheriff. Counsel for the defense are excused unless either of you have another case with another defendant pending. Mr. Favre, anyone else?
Judge, I've got a lot more, so maybe take up other people first.
Okay.
I have one more, Judge, Miss Michelle Miller.
Okay, let's look at.
The final major ruling goes against Dakota Sauter. After reviewing the bond amounts, criminal history information, and other pending matters, the judge declines to reduce the bonds and orders him remanded to custody. Another reminder that bond hearings can have immediate consequences. Like, comment, and subscribe for more shocking courtroom stories.